Notice of motion number 19. Debate on the gambling, advertising and sponsorship at state-owned or state-funded venues.
The Honourable Member for Nelson.
Thank you, Mr President. I rise to speak to motion number 19 in my name on the notice paper. The summary title reads, and I quote, "Gambling, advertising and sponsorship at state-owned or state-funded venues." But actually, Mr President, this chamber has already had that debate and already passed that particular motion. That debate and vote occurred on Tuesday the 2nd of December last year. It would be more accurate for the summary title of the current motion before us to be "Government Inaction on Previous Vote Supporting a Ban on Gambling, Advertising and Sponsorship at all State-Owned or State-Funded Venues," because that sums up why I'm raising the matter here today via this motion, Mr President. I do not intend to re-prosecute the arguments put during the previous December debate, nor should I have to. Instead, for the benefit of the members, I will provide a brief summary to assist in providing context for the current motion before us here today, a brief summary only. Last week I did circulate to members a background briefing paper which was an updated version of the previous briefing paper provided for the December debate last year. That background paper also contained the text of the previous motion on page 6, passed by this chamber on the 2nd of December 2025 for members' reference. And hopefully that document was sufficient to either refresh memories of members who were in the chamber at the time, or as well as to update those members who have joined us since in this place as to the intent and the content of the initial motion, which sought government action to transform all state-owned and funded venues to be gambling, advertising and sponsorship-free zones, inclusive of players' uniforms. As stated, Mr President, the intent of that initial motion was consistent with the 2023 Federal Parliament Standing Committee on Social Policy and Legal Affairs multi-party report called "You Win Some, You Lose More, Online Gambling and Its Impacts on Those Experiencing Gambling Harm." That committee, that laudable committee, was chaired by Peter Murphy MP, and despite the federal Labor government stated support for all 31 of the recommendations in the report, little action had occurred at the time this chamber considered the 2025 motion and had debated the motion. And we are still waiting for the promised reforms to be delivered at a federal level, in fact. However, Mr President, as stated last year, this chamber determined that in some areas Tasmanians did not have to be kept waiting. This chamber recognised that Tasmania could progress in some small yet significant way, the need to disrupt the social norm that betting and sport go together. It was recognised that by banning gambling, advertising and sponsorship within Tasmanian-owned or funded venues is consistent with current state government public health policy to treat gambling addiction as a public health issue, just as tobacco advertising and sponsorship was banned on public health grounds in such ways. Further, this chamber recognised it was prudent to require this policy commitment was implemented within a specified timeframe as proposed in clause 5 of that resolution passed in December. We should have seen by now an implementation progress report tabled in the Parliament. In fact, by my calculations, that should have occurred by early June. Mr President, specifically that progress report was to detail the removal of any gambling advertising from current state-owned or funded venues as an interim measure, while the complete ban was developed and put in place by December this year. And to be perfectly clear, Mr President, should the current situation be that currently there isn't any gambling, advertising or signage at venues or on players' uniforms, that's not an excuse for failing to table the requested update by the stipulated timeframe. In fact, such a situation should have made it very easy and concise to report on that and table it. However, any report would also have needed to be clear that if that is the happy situation for Tasmania currently, it is purely by accident, not the outcome of good public policy design, which is why a formal policy implemented by regulations or other appropriate mechanisms is necessary and should also provide the framing context for the requested parliamentary updates. Mr President, I will also note in passing that in the eventuality there is no current gambling adverts, branding or sponsorship evident in Tasmanians owned or funded venues or team uniforms, then formally prohibiting any such advertising and branding will not upset the status quo and should be relatively straightforward, I would have thought. Which brings us to the here and now, Mr President. Clearly the June deadline for the progress report has been and gone. without a formal word of acknowledgement from the government. I believe this chamber and the many Tasmanians who've been waiting for implementation progress on the December resolution have been patient. This current motion before us was tabled on the 25th of June this year. If the government had merely forgotten or had the timeframes had slipped a little, surely the tabling of this current motion would have served as a reminder, as a gentle jog of the ministerial memory, perhaps. The tabling of this motion 2 months ago should have served as a reminder to the government, although really it is not the responsibility of this place to have to provide reminders to government, as well as an indicator. It would have been an indicator that there are clear expectations that the original resolution would be complied with. The government has had 6 weeks, in fact, over the parliamentary winter recess to prepare such a progress report, delivering upon clause 5B in accordance with December's resolution, and then tabled that response during last week's sitting week when we returned from the break. Mr President, that is what would happen under a government that cares both for the welfare of Tasmanians and particularly our young people, a government which cares about acting on evidence-based information showing the destructive impact persistent and pervasive gambling ads have on communities, families and our young people, a government which cares about breaking the unhealthy nexus between sport and betting, and further and fundamentally, Mr President, that is what would have happened under a government that cares for and respects our democracy and our parliament and this chamber. Which gets us to the crux of the motion before us today, Mr President. This is not just a matter of a deadline slipping someone's mind. A formal resolution was passed by this chamber, one which was consistent with the government's current position of treating gambling harm as a public health policy matter, and which requested a formal progress report be tabled in the parliament within 6 months of that resolution's date. As stated in the current motion before us today, by my calculations, that date is the 2nd of June this year. I'll also point out that as we did not know the final 2026 parliamentary sitting schedule at the time the original motion was tabled, I did not seek to stipulate in which house that progress report was to be tabled. Further, as we all know, we do have mechanisms available by which reports and documents can be tabled should neither house be sitting. We attempted to be as flexible and reasonable as possible regarding that 6-month milestone built into the original resolution, but apparently those goodwill efforts have been snubbed by the government, which basically boils down to a fundamental disrespect shown to this chamber and therefore also to the Tasmanians we represent. This was a formal vote securing a formal resolution by a democratically constituted chamber of the Tasmanian Parliament. On what grounds can it just be ignored? Mr President, occasionally we'll hear about the apparent limited remit of the House of Review within a bicameral parliament. Let's address that briefly here. Members do not need me to tell them that we are working within a bicameral Westminster parliamentary model, but what does that mean when considering the respective powers and roles of our 2 chambers? That is obviously an extensive question spanning constitutional law as well as parliamentary institutional design, practice, conventions, so I'll restrict myself to detailing the elements specifically relevant to this debate. The relevant political science literature identifies a bicameral spectrum within symmetric models at one end and asymmetric models at the other. And the asymmetric model is where one house, usually the upper house, is limited to varying degrees of a legislative advisory and delay review role through to being clearly subordinate to the House of Government. Bicameral parliamentary Westminster models considered to be asymmetrical include the Canadian Senate, for example. More pertinent to this chamber is the fact the Australian Senate is characterised in the literature as an example of the symmetrical model, specifically one that is co-equal with restrictions. That this reflects an equal capacity to introduce, amend and vote for or against legislation, with the limitation of or restrictions referring to the fact lower houses and government have a clear priority when initiating or considering financial legislation, also referred to as money bills. Mr President, I think we can recognise this chamber has a similar relationship with the other place within the institutional design of this Tasmanian bicameral parliament. Other than money bills, the policy space of this chamber is wide. We can roam across the spectrum of public policy utilising a range of parliamentary mechanisms available to us. Such mechanisms available to this chamber include the capacity to establish committees into matters of public policy, to put formal questions to ministers of the Crown with a corresponding requirement that a response is provided, to amend government and non-government bills either originating in this or the other place, to propose bills from this place, both government and non-government, to table petitions on public policy and other matters, and to have dedicated private members' business time that is formally provided for in our standing orders. Further, Mr President, it's worth restating quite clearly that under our bicameral Westminster parliamentary model, the executive is subordinate and accountable to the Parliament. That also applies to this chamber, which is why questions asked via this place are taken as seriously by ministers of the Crown as are the questions asked by the other place, for example. Mr President, I thought it pertinent to articulate some of those mechanisms and tools which we utilise to go about our work in this chamber on the off chance there may have been an attempt to try and justify the government's failure to act upon the previous resolution of this place on the dubious grounds this place is only a House of Review and therefore resolutions on matters initiated by non-government members are somehow less serious or real than any other democratic vote undertaken in this place. Traditionally, yes, we have inherited the role and responsibilities of a House of Review, but constitutionally, we are not limited to only those responsibilities and that role. I note this reality has caused frustration to a range of former premiers who have at times wished to corral the chamber back into that particular box. I recognise how a co-equal with restrictions bicameral model can show up a listless and spent government of the day, can annoy a government when its legislative agenda is amended and frustrate the executive by probing government activities it would prefer remain unexamined. But quite simply, Mr President, that's just too bad. As our current model demonstrably holds the government to account, serves as a check on executive power and furthers the interests of our electorates and the broader community, then I'm not going to apologise for working to deliver on those responsibilities. So please, let's not have our time wasted here today by any such weak try-on that the chamber exceeded its review remit to attempt to deflect from the government's failure to respect this chamber's December resolution. Mr President, having established this chamber is not subordinate to the other place, I wish to briefly touch upon the principles of comity. I did provide a simple summary in the information circulated on Friday to members, but in the interests of providing a comprehensive debate as possible here today, it's also necessary to outline some of those concerns.
The sitting is suspended until 4:30 p.m.